filed everything. How many matters are there? 40 and 132. 240. 3 matters.
Your Lordship, good afternoon.
Yes. ये कौन है?
My name is Samarthya Vishwakarma. I have filed a miscellaneous application 5312. I want to join as a private respondent in the Abhinathan case.
What should you?
You filed the application. It is not on record here. You filed
Yeah,
to
I have the diary number right now, 5312. It will be filed.
Okay, then you get it listed. You get it listed there.
Okay.
Okay, na? Yes.
This pertains to the result of CGL combined graduate level examination 2024. I filed the away method, and my prayer is not by your officers are greatly aware of the dispute not by that. Yeah. My prayer is not saying is at page 52 of my OA. This is not my opinion. Just brief background development, and I will go to the crux of the issue.
Yes, 52.
Page 52. I say, where's the impugned result dated 12/3/2025 in Excel A1 to the extent of exclusion of the names of the applicant? I say that direct the respondents to include the name of the applicants in the final selection list and consequently direct the respondent number 1 to not suitable job of the applicants in terms of the medical practices. And in the alternative, direct crossing of CGL 2024 to the extent of paper 1, section 1 of Tier 2 exam in direction to conduct the same again after giving you. Then there is some interim prayer also. When I came to your losses will not be initially issued this, but will not mean there was no direction for stay, will not mean I went to High Court says it has to be subject to wait, and thereafter will not mean I came back to your losses. The OA had been filed with on the grounds, amongst others, that this advertisement will not be 24/6/2024, that is Annexure A3. The clauses thereof will not, conditions thereof will not, but this is Annexure A3. It was not followed. This was my submission. I said will not be so far this exam is concerned, Tier 2 exam is concerned. There were two papers, one on 18th January 2025 and another on 20th January 2025.
Tier 1 is separate. You are not questioning the tier 1.
Tier 1, I am not questioning, the reason being, we were not affected by it. Just a moment.
When I am asking, I am anyways taking note.
So far, tier 1 is concerned. It's not that it was without any issue. Issues were raised by certain candidates who were affected by it. And ultimately, your losses had passed an order. If the losses may kindly see, this volume 2.
Candidates.
One was questioned and a relief was granted. Volume 2.
Volume 2 में ना?
1026 Annexure A12.
Yes.
1026.
So this OA is also pending.
Is it pending?
Ah.
It is pending, but we lost this as per. Is it pending or is it disposed of?
It is pending actually.
Your losses had granted interim relief to the applicants. His losses said that you can appear in Tier 2 exam. according to this is Malot mein 16th January 25 order. So these people Malot mein who got relief Malot mein they appeared on 18th and 20th Malot mein depending upon whether sick they will be Malot mein present. So it's not that Malot mein tier 1 Malot mein was without challenge. It was Malot mein challenge. Expecting new losses granted people appeared in the exam. So when I came to your losses Malot mein I questioned two things. I said after 18th and 20th, two exams you conducted, tier 2. 21st, you gave tentative answer key. This is as per advertisement dated 24/6/2020. And at that point of time, you lost. You lost it, may kindly see the index only. The index of volume 1. See the index below.
Yes.
Annexure A2 is Malot mein one notice dated 7/2/2019. This is Malot mein about this normalization. This is an accepted thing, not disputed. Advertisement it says Malot mein if there is multi-shift examination Malot mein there is a possibility that Malot mein students there can be some variation in marks Malot mein. So for the purpose of equalization Malot mein they say this is the way we normalize this is mathematical formula. So Malot mein this is not dispute so far this is concerned. Then after the exam annexure A4 Malot mein as per once again this advertisement they gave this tentative answer key of Malot mein tier 2 on 21st January 2025. Rule says Malot mein I will show the rules. Rule says that at that stage when you got it and if you have got any grievances you approach Malot mein this Malot mein staff selection commission they will look into it and accordingly they will penalize this one Malot mein master answer. I do not know Malot mein who has raised the grievances. I have got no idea. I have brought on record Malot mein this information Malot mein is sought to be obtained under the RTI Act. There is no response to it. There has to be some trigger point Malot why the result is required to be modified. I have no answer. They may have the answer Malot mein. I asked in the RTI Malot mein no response. They said nothing doing. They are not going. So tick. Thereafter, Malot mein I brought on record as per this Malot mein tentative answer key Malot mein Excel A5. The marks.
चित्र सहित है
It is unnecessary noise.
The marks Malot mein that we have obtained. We also said they give some kind of a URL what they say Malot. The staff selection commission provides that look this is the answer key. You can check that how much marks you are going to get. So we were convinced that we have got substantially higher marks and we are going to not get into it. At least these people who are before your losses they did not make any representation that look this tentative answer key is wrong. You have to change it. So thereafter Malot mein find Malot mein this result came on 12th March 2025 and much thereafter Malot mein on 18th of March Malot mein they gave the modified answer. We were surprised to see the result that how is it possible that the persons who has appeared Malot mein who has got 324 or even 340 marks, 340 marks or whatever Malot mein he was not selected and person who has got only 299 marks he is not selected. Normalization could have Malot mein 18th and 20th two exams were there Malot mein. So for normalization marks is there Malot. The difference cannot be more than 5 marks. There is a huge gap of Malot mein 20 marks to 60 marks.
No.
It was impossible.
The result is declared on 12th of March. And how you are saying that a person of 340 marks has not been selected? 340 is your calculation as per the tentative answer key.
As per the this is their answer key, this is their URL, and this is my calculation, and I have given it.
So at the time of the tentative answer key, you have calculated. You think you should be getting 240, 340.
Answer key, their URL.
And when the final result is
Figure out.
you were out, but now you don't know your marks.
No. I got my marks Malot mein as per this Malot mein modified answer key. Modified answer key.
What are your marks now?
No Malot mein it has Malot mein slightly come down.
Oh, obviously it will come
It has
down.
come down. So that is the Malot mein situation, and the persons who have got 299, they are into the list, and person who is 340 is out of the list.
That's what I'm trying to understand. 299 as per the tentative,
My lord,
but after normalization and after modification, he has got in.
he is got it.
But a person with after tentative was at 340, for some reason he has been out.
He is out. So what is that some reason, my lord, that is the most crucial. When I came to your office, I stated,
So so there are two things that the marks could have been inflated or deflated due to normalization. You say that if normalization is applied, there will not be a difference of more than 5
white
marks.
marks.
So a person 300 and 340 is a huge difference.
My lord,
So the other issue is there may be some questions
my lord, my lord.
whose answers are right or wrong or whatever. So now you are not on the normalization, you would be
I am
only
not-
on the question answer.
Normalization comes later on. My lord, which will, my lord, ultimately after this master answer key is looked into, my lord, it can be decided that how this normalization will be applied. No issue with normalization.
Mr. Counsel, you claim to have got marks like 324, 340 based on the tentative answer key or based on the modified answer key?
Tentative answer.
Tentative. And that is their calculation that they should
But
have.
that is my calculation. They say that this is vague. You have relied upon some rank mitra. Rank mitra is one thing, my lord. Why don't you give me that what is my marks as per the tentative answer key?
So these are based on the tentative answer key.
Tentative answer key.
If you base your marks on the modified answer key, what is your score?
Then there
My
are
lord, it has come down.
just come
Then
down.
you are out of the list.
I am out of the list.
So you are challenging the modified answer key.
I am
The
challenging.
long and
the-
short of this OA is that
No,
modified
no,
answer
no,
key is
no,
erroneous
no,
and mala fide.
No. Malice is there. When I came to your losses, I stated, my lord, that you publish your result on 12th of March. I do not know who objected to, my lord, this tentative answer key. And thereafter, my lord, the result is varied, which is an impossibility even after normalization of 5 marks. I said that you have ultimately selected the persons of your choice and their malice is there. And thereafter, you modified the answer key and you gave it on 18th of March 2025. So there is a bias, my lord, inherent, my lord, in the entire process. When I asked this, my lord, they say that you did not challenge this tier 1 exam. We have followed the same thing in tier 1 and you are doing it in tier 2. This is not possible. My lord, Supreme Court.
Candidates, you can please remove them from the backside of the
For us,
council.
just let the oxygen flow in the room.
Not from the podium.
थोड़ा सा side हो जाए. हाँ.
What they are doing here, kindly see them.
Candidates
Sir, it is-
side,
it is the
candidates सारे
public
side
vote,
पे
sir.
हो जाए.
Public court, but they cannot.
Public court, anyone can either subject to your losses.
Candidates थोड़ा side में हो
थोड़ा
जाए.
side हो पीछे हो
हम लोग इतना वैसे ऊंचा बोलते हैं सबको सुनाई दे रहा है.
थोड़ा पीछे हो थोड़ा
नहीं तो आपके अनुसार मिस्टर सिन्हा जो टेंटेटिव आंसर की है और जो मॉडिफाइड आंसर की है उसमें क्या अंतर है?
नगर में उसमें ये है कि 22 क्वेश्चन जो इन्होंने लिए
कितने 22
22
क्वेश्चन का आंसर में 22 क्वेश्चन में डिफरेंस है.
difference है. And when I said, my lord, I pointed out in my OA also that as per the modified answer key, you have made mistakes. Because these are the government data, these are the NCRT books, these are the things, my lord, which is, my lord, accepted by everybody. So you could not have done it. So that is wrong. So your modified answer key is wrong. You change the result on the basis of this modified answer key, and thereafter you applied this normalization. Sir, please, sir, please. Thank you.
The
Yes, sir.
permission of the my lord, this is not the modified answer key. It is wrong word which is used, it is the final result. It is not modified answer key.
The final answer key.
For them, the
As per the
tentative
scheme
was
of the
good.
examination.
ठीक है, doesn't
The
matter.
final answer.
Final answer
Yes.
key. There is a tentative and there is a final
Yes.
answer.
चलिए,
तो 22 क्वेश्चंस में अंतर हुआ है.
23.
Additional problem is a change in one answer makes a difference of 4 marks.
Negative marking.
-1 that will be.
So result will be changed. So once I filed it, my lord, and after my lord, all these my lord, things, they filed their counter affidavit. And in the counter affidavit, my lord, they say at page 24, the losses to see the counter affidavit.
वॉल्यूम 2 में है.
In the counter, sir.
Yes, counter affidavit.
Para 24, my lord, at page 26.
पैरा
24, page 27.
Yes.
There is no reference to standardized textbook or prescribed textbooks in the notice dated so and so. And therefore, it is incorrect to assume that certain textbooks have given prescribed or they form standard books. In fact, the only reference in the notice and legal clause is the respondents have not prescribed any textbook, and therefore, textbooks such as NCERT cannot be the basis for any challenge to opinion of the subject matter experts. Such reliance over textbooks in academic evaluation matters in suppression to answer key prepared by experts in the subject has been struck down as bad in practice in the following cases. So now, my lord, the dispute, my lord, lies here. What they say, my lord, that they have got their own set of experts. This, my lord, staff selection commission, my lord, it comes under the DOPT. NCERT, my lord, is under Ministry of, my lord, HRD. So what they say, my lord, that these textbooks, these government publications, it has got no bearing. I have, my lord, appointed our own experts. My experts, my lord, read books. I do not know from where, my lord, and from where, my lord, they give information. So whatever information, my lord, their expert is giving, that is correct. And this NCERT, this government, my lord, nothing is binding on them. So this is the nutshell, my lord, of the things that your lordships have to decide.
So, but was this question subjective or objective?
Subjective. Subjective as an objective question. So sorry.
All objective, no?
All objective.
And based on facts.
Yes,
Based on facts.
Like I and the member Jay were discussing the other day, if the question is, where is Mongolia located? It's in Asia. Where is Mexico located? It's in the American continent. If the questions are objective and factual, there should not be any difference between the tentative answer key and the final answer key.
Absolutely.
And that too, you say 23 questions.
23, not 1, not 2, not 3, 23.
Which is quite outrageous.
That is the thing. And they say that nothing doing. No NCERT, nothing, no government. They are not.
Whether it is NCERT or whether it is CBSE, fact is a fact.
Fact is that, but they are not relying upon it. Now, my lord, in this background, my lord, kindly see my rejoinder affidavit. I am straight away, my lord, coming to the point. The reason, my lord, before my lord, I go there, they have also relied upon my lord, one thing.
आप 23 क्वेश्चन बता रहे हैं ना?
23 questions.
11 questions from the 18th generation and 5 questions from the 20th generation.
It is 90 question. Marks were given to all.
मोबाइल ले जा रहे हो मोबाइल
Three questions. Options were changed.
So let us see the rejoinder. Let us see rejoinder.
Just a moment. One thing. About this issue of my lord, whether your lordships have power to intervene, my lord, with their subjective view or their subject expert of law, it is well settled. High Court, my lord, followed the Supreme Court judgments. Supreme Court even lately, my lord, in the
We
case.
have relied on 3 judge decisions in para 24.
My lord, that's correct, my lord. And my lord, this staff selection commission, my lord, versus Subham Pal, Delhi High Court has given a detailed judgment, and that is the law, my lord, which has been taken to Supreme Court. Supreme Court, my lord, further, my lord,
I'm going to add up to my senior lordships. The previous Shubham Pal also pertains to the SSC issue. Every year there are some issues to the questions and answers. Lordships. It is not a one-off practice. It's all a model practice.
my submission is, your lordships have the power. There is no dispute. If your lordships want me to read the judgment, my lord, to certain points, I can, my lord, show it to you. If they say, my lord, that your lordships do not have the power, my lord, there cannot be any judicial review so far subject expert is concerned, this is one thing. But in that,
So you wanted to read from the rejoinder.
I wanted to read from the rejoinder only for my lord, 1 second. This staff selection judgment, my lord, I have also quoted the commission. Kindly see para 3. But may kindly see para 12. Para 11 onwards. So for the legal issue is concerned, then I will go to the facts. That said, However, it is equally obvious that the sphere of judicial review cannot be altogether foreclosed.
You didn't para 12.
Para 11 I am reading.
Okay.
However, it is equally obvious that the sphere of judicial review cannot be altogether foreclosed when such challenges arise. There may be cross cases or cases in which it is evident without any necessity or rationalization or intricate reasoning that the answers under challenge is palpably incorrect. In such case, the interest of substantial justice have to prevail, and students who have attempted the examination cannot be allowed to suffer merely because of an obviously incorrect answer suggested by the subject experts. Now, my lord, may the Supreme, my lord, may High Court courts, my lord, may various Supreme Court judgments, and my lord, may para 12, my lord, may sub Roman 1 onwards. This is the law. And Supreme Court, my lord, may Delhi High Court, my lord, may as well as Supreme Court, my lord, may followed, my lord, may in this all these things, my lord, may in this CLAT judgment also, my lord, may have it. It was in New York. It says 12. I am reading my lord, may 1 Roman 1. Circumspection is the general rule, especially where experts have considered the objections raised to the answer key. I do not know who the experts are. It is, however, equally the rule that there is no absolute prescription against courts examining the challenge to the key answers, even where experts have opined. The law does not commend or even recommend a hands-off approach. In an appropriate case, the court can even examine for itself the correctness of the answer, the key answers under challenge, in which process the court is also empowered to refer to authoritative textbook on the subject, especially those which form part of the student's curriculum. Where the question is simple and not admitting of any complexity and can command only one answer, which is apparent to the court is not proscribed from taking a view based on its own perception of the question. To take an extreme example, the sum of 2 and 2, that however would have to be in a rare case in which the answer is so apparent that there can be no doubt about it, and not one where the opinion of some expertise would help or where there is ambiguity. In any case, the guiding principle is that the general rule against accepting the suggested answer key stands relaxed. Only where the suggested answer key is proved to be wrong, an inferential process of reasoning or rationalization, but clearly and demonstrably wrong in that no reasonable body of men well versed in the subject would regard the key answer as correct. Then, my lord, may the same thing, my lord, may has been repeated here. I am not going, my lord, may into all these things.
Even if there was any lingering doubt as to the tribunal's power to differ, especially for multiple choice questions, Delhi High Court and the Supreme Court have multiple times reaffirmed that, especially for MCQ answers, objective answers, courts and tribunals do have the power to interfere. If required,
So, my lord, may power, you lost his power, my lord, may in power of submission, my lord, may as per the Supreme Court and Delhi High Court judgment, my lord, may Delhi High Court is once again based on the Supreme Court. Your losses have the power. That's the crux of the. That's the crux of the matter. Your losses can, my lord, may proclaim. Now, before I, my lord, may go to the rejoinder affidavit, if your losses may see my OA. The grounds, my lord, may starts from page 11. That is para 5, will not be the format. 5 point Roman 12, page 14 onwards. I have, my lord, may given the list of questions.
Para, this is rejoinder.
My lord, may I am showing from the OA, my lord. I will come to rejoinder immediately. Page 14, my lord, may of the OA. Para 5, my lord, may Roman 12. OA, my lord, may I am showing. Volume 1.
Page 14.
Page 14. So I have given the details of questions, my lord, And the variation in this, my lord, by tentative and modified answer key. There is no response to it, my lord. And
This
this
is a
is,
mathematical question, simplify, this is a algebraic equation.
these type of questions
Reasoning
are here.
also, my lord, reasoning also. The
No, this
statement
has to
of
be
the
objective,
applicant
mathematics is
correct.
objective.
My lord, the statement of the applicant to this extent, they are the geography question on and all that question.
Mathematics is
Correct, my
objective.
lord, mathematics questions and reasoning questions.
My
Also
lord,
there, my lord.
my lord, my lord, my lord, my lord,
There is
we will come to.
Mathematical calculation also required. It's a Pythagorean triplets lordship. This is the 5, 12, 13. It will be 25, 144 and 169 lordships. Even somebody of class 10 can solve this question, your lordships. This is not a complex a polynomial equation or anything. It is a very simple question. Objective answer, there is only one answer. Similarly, for the other questions also we demonstrate your lordships.
So in
The
this
math-
question number 2, what is the correct answer as per the initial answer key?
My lord, for 1 minute.
Because in maths, you can't be having,
No, there can't
There
be
can
two
be
answers. There can't be.
maths, you have to be very
My lord,
objective.
after their counter evidence.
Then the next question, Rani and Adya,
My lord,
is also a maths question.
when the question pertaining to irrelevance. Now, my lord, may in this, my lord, may in this background, my lord, if you losses may kindly see my rejoinder ability.
Yes.
The losses, my lord, may on the last date of hearing, he asked me that you prepare a chart showing the questions and tentative and modified answer key and points. So, Elixir A15, page 17 of the rejoinder, my lord. For your losses convenience, my lord, I have made this chart, which is, my lord, may further running page, my lord, may of this, my lord, may the questions.
We have given the explanation as to
Explanation.
what will be the explanation for your right answer. So the, let's say page 70, tentative answer key was 16.8%. Full
My lord.
marks.
My lord.
What does that mean?
Page, now, my lord, may come to page 19.
This is volume 1 or volume 2?
This is in the rejoinder. I said I have summarized all these things. He was wanted me to give it a chart.
So 22 questions are here.
My lord, may 23.
So you have added one.
Which page in the journal?
Page
My lord, may
17.
page 17 is the chart. And if
Here.
I have page, my
So
lord,
you have given the explanation ki why.
17 and 18 is the chart.
Yes.
For the 18 January, we've given a separate list here, lordship, that is part of my role, but I'll come to it after.
So this, all these questions are of the,
Both my lord, may 18 and
for
20.
both and 20. ठीक है.
This is the chart, and my lord, may come to page 19 first. First question, my lord, may this is tentative, my lord, may I have said. According to Census of India 2011, what was the recorded population growth rate of Hindu? The correct answer as per the tentative answer key, my lord, may is 16.8%, and we, my lord, may say this is 16.8%. But once the final, my lord, may or modified, whatever they say, final, let it be final answer key, my lord. It says, according to Census, what are recorded so and so. Says is note, for this question, discrepancy is found in question stroke answer, full marks is being awarded.
So they deleted this.
They say no, to delete this question, give marks to everybody. So, my lord, may 3 marks, my lord, may for correct answer, I lost. 1 marks, my lord, may for negative, my lord, may, so, my lord, may 4 marks, my lord, may, there is a gap in the sizes, my lord, may because of this.
And
Now,
there is
why?
one interesting fact. So candidates who have not attended the question, they have also secured this marks, 4 marks.
There are two reasons why this becomes relevant. Number one, Supreme Court in Guru Nanak, as has been pointed out to your audience, has specifically said
There is no negative marking.
has
The
specifically
difference
My
between
own
laboratory examination
cannot be
is
awarded to
that
all
there is no
candidates,
negative
but
marking.
Wait.
but only to candidates who have attended this. This
So,
second thing
yes,
is
so giving the marks to all candidates, whether they have attempted or not attempted also is.
I'm covered by the recent judgment of the Supreme Court, IIT 2017, and my lord has dealt this issue up to the line. I will apply upon that.
Situation is, situation is,
There is no negative marking. In IIT 2017 was negative marking.
may not may, doesn't matter, my lord, even if negative marking is not there, if I attempted it, my lord, and I have given marks, if it is wrong, my lord, may, the entire mark.
It is dealt by the honorable Supreme Court, my lord.
Just a moment, just have your turn. Just a moment, have your turn.
just a moment here. There are two reasons why this bonus marks becomes critically important. Within the same day examination, Perhaps there may not be a significant variation in marks on this, but your examinations are conducted on 2 different days. Therefore, when bonus marks are awarded to candidates who have not even bothered to read the question, your lordships, in normalization, candidates who spend time, effort during the examination and have attempted this question at the cost of perhaps another question, they are significantly disadvantaged, your lordships. This disadvantage that is caused to candidates who actually spend time in the examination for a question is why Guru Nanak Dev has said the other way.
In simple words, what my friend is saying. If a person prefers to answer, do not answer these 22 questions, normal course will get 0. But after this Broadway, he will be given 66 marks more. When he's going to 3 marks, he goes to 6. So if I did nothing, Broadway, I got 66 marks. So this is what I intended to say. But Broadway, first come to the Broadway, the merit of the thing. Now they say that there is a discrepancy. Page 20 Broadway, kindly see. I have given the details. I have said that how these are affecting the questions. Can ignore this aspect. Answer details justification, kindly see. Page 20 bottom. The correct answer to this question is verifiably of the score 16.8% as supported by official data from the Census of India 2011. According to Census of India 2011, the Hindu population grew from 827 million in 2001, representing a so, this data can be cross-referenced from the official census report published by the Registrar General and Census Commission India. And that I have annexed it here. I have pointed it out. This press information here. This is Government of India's data registrar census. It says at the bottom, page 21, 16.8%, Hindus, 54.6%. So this is government data. They said no. This is fake. So there are answers to page 22 line is. The same question was asked in SSC CGL. And here once again the correct answer was 16.8%. Exactly the same question. Same question.
But if the respondent the flat stage as per the examination results.
Now there is a change of 4 marks first question. Now may go to page number 23. Tentative answer key. How many meaningful English words can be formed using first, third, sixth, and seventh letters of the word recognized when counted from left to right using all the letters, but each letter only once in each word? The answer is none. Tentative is none. We prefer for none. Now they say in the final answer key it has to be 1. So first, third, seventh, 4 letters are R, C, N, and I. We did all kind of permutation and combination. These people have read mathematics also. They have done all permutation combination, and they say that there is no word of English which can be formed with R, C, N, I. There is one word green, which is possible, but green is a French word. Page 24.
Not a French derivative word, it is a word in French, not an English.
It's not an English word. The question is English words.
So the tentative answer key said that you can find, you can make one word.
No, none.
You can hand over a copy of the dictionary also.
Tentative said that no word, but final said one word.
My lord, what is going on? They are handing over the dictionary, my lord.
So we show that.
So we can, will not be the high court, will not be high.
The case being argued or my lord, something else is going on. My lord, if everything.
Ajay 639
My lord, it should come on record of the court. Everything should be handed over to the court, my lord. What is the practice and procedure, my lord? They are practicing.
I strongly object to it.
Today is the day of that.
I strongly object to it. My friends should not make this kind of a statement. If I court looks into the dictionary, The Supreme Court looks into the dictionary. 1, 2, 3, 4 dictionaries. Even my
This
friend might not be aware
never
of
takes anything on the argument.
If you turn to page, Mr. Gyanendra, please, I will not allow you to speak. If you turn to 24, then dictionary is not even required. You have listed out quite a number of the
all these
options. That
This is the
letters which can be,
possibility, my lord.
yeah.
When this grades upon my lord, when they have caliber that what kind of students are there that have done all these exercises. We have done nothing. We have only now, my lord, he says that I am handing over the dictionary. Bottom 24 bottom I said the Oxford dictionary which was designed upon my Honorable Delhi High Court in Shubhampal in SSC, which I am referring to that I have just told to you.
Shubhampal has been listed by the Supreme Court.
It is similarly situated.
17/12/2024.
The word bean does not appear in the
भाई अपने माइक बंद करो
This way, what I have given a special time for this, and that too at the cost of others. Then if you keep on interjecting like this, then we can't proceed further. So except the council who's arguing, if anyone else, this is a warning to all of you, then I will not proceed any further. That's why I'm saying.
What kind of a thing is
Mr. Gyanendra, again.
Even in the court martial, my lord, it's a people's court, anybody can go.
Only the arguing counsel will speak. All of you will remain silent. We'll give you time, or you make your notes, or give him in slip or whatever. Let him proceed with the rejoinder. I think it will cover everything.
Correct.
Chal.
Now, my lord, may come to the third question at page 27. Now, this is mathematics. The average of first 92 even number is, now 4 options are there, and the correct answer is 93. That's the tentative.
So for this, they have awarded full marks.
Full marks, they
To
say that
everybody.
there is a discrepancy.
Okay.
Is my lord. Is 22 Broadway philosophy, kindly see. What is the average of the first 4 number? Even number. First 4 even number Broadway is 2, 4, 6, and 8. That is 5. So whenever we calculate Broadway first 4 number, it will be 5. First 4 even number Broadway average will be 5. The question was first Broadway 92 even numbers, to answer will be 93. Broadway, this is once again Broadway mathematics. It's a correct thing. So here the formula is page 29. Broadway I have said. I have said second, third, fourth, everything I have said. 29 bottom Broadway NCERT book class 6 math chapter 3 playing with number. Page 29.
चलिए ठीक है आगे चलिए
क्या आंसर इसका क्या सही आंसर क्या 93
93 is the correct answer.
both in tentative and final.
No, final they say marks to all. This is vague.
वो के हिसाब से कह रहे
Where lies the problem? The problem is 0.
What
is 0?
It may get missing. The balcony है ना वहाँ से धूप नहीं आती है
No,
the
question.
अरे भाई अपने माइक बंद करो भाई माइक बंद करो अपने
12, 14, 16.
भाई अपना माइक बंद करो ना
Why they say it is vague?
तुम लोग हियरिंग क्यों
This is
खराब कर रहे हो यार
that is the reason Milord, where we say we have produced this class 6 NCERT book. It says
अरे सभी लोग अपने माइक बंद करो
And
चुपचाप
93
सुनो
is the
यार
right answer. 93 is the right answer.
No, it says that the smallest even number is 2.
Yeah.
So they say that in NCERT they are being taught that the smallest even number is 2. Therefore, 0 cannot be an even number. Therefore, it will be 93.
start with 2
Even
Milord.
if you had
चुपचाप
0,
रहो
the
अपना
answer
माइक
would
बंद
not
करके और हियरिंग सुनो यार
0 with 0 Milord में answer will change.
change. वो 91 तक चला जाएगा.
हाँ, 91.
With 0 Milord में answer will change.
But 0 is neither an even
But 0
number
is
nor odd
not
number.
Milord with the even number.
0 is neither
Smallest
odd.
even number is 2.
0 is neither odd nor even.
Milord. So page 30 Milord में is the Milord में the class 6 NCERT book. It says which is the smallest even number. Now the same question. Page 32 Milord. It was asked, my lord, in staff selection commission itself. Lord. What is the average of first 39 even numbers? Page 32. The formula that I gave, my lord, it has to be, if it is first 39 even, it will be, my lord,
Answer
40
will be
and 40 is the
40.
correct answer. And first 29 even numbers, correct answer is 30. So this is the way, my lord, it proceeds. My friend is saying कि mathematics की तैयारी करता है. At that point of time, you will office to recollect. This will office not accepting the civil service exam.
तू आ रहा है प्रीलिम्स तो आ ही रहा है. मुझे लग रहा है कि हम प्रीलिम्स में चले जाते हैं. अभी जाइए हम भी जाते हैं. इस इतवार को प्रीलिम्स एग्जाम है. हमने जैसे अभी दिया है.
If you office to recollect at that point of time, Lord, they know everything under the sun. At least at that age, Lord. This is the level of the preparation, Lord, at that point of time. If you office tell me to give, Lord, the answer to all these things, I won't be able to do it. I better request to them that please you do all these things. So they did the exercise and I have just.
So basically now from the rejoinder, we can gather that for each and every question which you have placed a doubt on, you have given an explanation.
Explanation, my lord, may supported by government data, NCRT books,
Yes.
etc.
So now all the under the system of examination, there is no chance to you to give these point out the problems with the final key. This is a problem with the final answer key.
Final answer.
There is no chance afforded to the candidates who have now been ousted to.
That's correct.
Yes. So now that it has been raised, you have seen the rejoinder. So what is your stand? Only simply to these questions.
Just a moment. I backed up all these things in my OA also. There is no response in the counter, but for the fact, look what NCRT, we don't believe in any NCRT. We have our experts.
Okay, नहीं, because see some of the questions, let's say चलिए वो maths वाला छोड़ भी दे, but then वो percentage वाला है, the census वाला, there is a proper advertisement on that.
There is official data.
You can't be just brushing aside. I'm sure if I go through each and every question, 2, 4, 5, not 22, 23 नहीं मानो, 4 or 5 questions will be there. For which even you, for example, that RCIN wala. You can't say that. So therefore, this is a time where the SSC should introspect and see that if any mistake has occurred with the final answer key, they should again verify that.
Hello, first of all, how the answer key is prepared and get it in final answer key and giving the.
That you have argued on the earlier occasion, and now we are not. He has very smartly left that point today, on which we have noted in the first. That is how the timeline that the officers were called, and they have adequately explained that the timeline between the result and the final answer key. So that was the process they had followed in tier 1. They have been following earlier exams also, and one of the officers who came, he said, now in the next notification, you will see a note also, because there is a little bit of a problem with the, so that point we are not touching. Now the point is regarding these 23 questions, because some of them, even looking at the basic English, some basic mathematics, some of them we also find that, giving marks to all candidates is actually awarding people who are actually not deserving.
Yes,
and this way, you as a SSC, your motto should be that we have to select the person who's most deserving. And it's after all a competitive examination. So what we would, at least I would feel that after the rejoinder has been filed, the SSC should have actually looked at these questions and then come up with the final.
For that reason, when I was importing Buchi on them, I said if 21st January 2025 you get the tentative answer, if we are satisfied to these are the marks, we will get it. We may not get it, that's different. If the variation in result is there, And thereafter on 18th March, they say that we follow the same principle because we followed this in the preliminary Tier 1 exam also. My submission is where it is written in this advertisement that you have to give this final answer key only after the result is published. It says that if you have any objection, you point it out to them, and thereafter their decision will be final. So who pointed out? So far, this tentative answer is concerned.
Who raised, because there are lakhs of candidates who have applied and have participated. So there few hundreds are here. So we don't know across the country how many have given their objections to the tentative answer.
They have not stated, and this I said, my lord, may even in my this RTI application that you the questions, the objections that were raised after this tentative answer key, they said who will not give it. That is the reason I am saying they have selected the candidates. Now they have to show that how they are selected.
So that theory is a little far-fetched because
I am constant.
if we don't credit them with that kind of intelligence or mathematical or algorithm or that kind of machinery to pick and choose and then to modify the result in a manner that their chosen people come in. It's an extreme. So it's one for a smaller exam interview perhaps, but this kind of a huge exercise they can't do that. But yes, about the 23 questions, that is one in my mind.
Yes, my lord. We are ultimately, my lord, zeroing in ourselves, restricting ourselves.
The rest of the grounds.
So, my lord, so far this is concerned.
So their only defense is that yes, we have an expert team, and that expert team has prepared the final answer. But show these 23 questions to your expert team, and let us have their reasoning vis-a-vis challenge to these 23 answers with their reasoning.
When this tentative answer key was prepared, I am supporting my friend. Everything is done by the experts and nothing is done by the staff. So once this questions were set, and tentative answer key was prepared, it was once again their experts. Nobody else was there. So now another set of experts they brought and they said that you modify it. And they said, no, let us change the mathematics. Where is the problem?
This issue has already been dealt with more than 1,000 judgments by this court, High Court, and the Supreme Court, my lord. And my lord, one another type of argument, my lord, on which I am relying upon, my lord. I am covered by the order and judgment passed by the Honorable Court in C. Girja Vyas case, my lord. I am just handing over the copy of that judgment. A person who has applied for the examination after going through the scheme of the examination and contents of the advertisement,
they are not. अरे वो चीजें खत्म हो गई. नहीं, Mr. Gyanand, you read para 10.
No, I am not.
I am only reading para 10 of this judgment. 10 and 11. 11 पढ़िए.
It is stated by the Honorable Supreme Court. It is stated by the Honorable Supreme Court. 17th December 2024. SLP number I am giving the SLP number. Applicant is relying upon the law.
Supreme Court has stated what, my lord? The
Supreme Court has stated the order and judgment passed by the Honorable High Court, while SLP Civil Diary number 55798 of 2024, while this order dated 17/12 of 2024. Now, in terms of the order passed by the Honorable Supreme Court, this is not a good law for time being. My respectful submission is that the argument on which the applicant is relying upon of this Subhampal is no longer good law for time being. So this argument of the applicant does not come any help for the applicant. I will supply the copy of the now.
ठीक है, we believe you.
May I say something? What my learned friend is submitting, that is absolutely incorrect. This stay order was passed in a different context. Some groups for it.
My lord, I am sorry.
No, just group of students didn't challenge that question earlier. So giving liberty to those group of students, Supreme Court has stated this.
My lord, the Supreme Court has been filed by the Staff Selection Commission.
Point is the stay is there, so we don't know what will be the final. Actually, that is one aspect. Now there are other judgments also which you are relying on. So now the issue boils down to what is to be done with respect to 22 plus 1 question 23.
Yes, what I am submitting. What my friend is saying, if I understood it correctly, that if I have participated in the exam, I do not have a right to challenge the exam. I am not challenging the exam.
Arey bhai, we have not given any credit for that argument because he is saying that is only restricted to the scheme of the exam. You are not challenging the scheme.
My lord,
इतना तो हमें भी credit दे.
I'm so sorry. I am so sorry.
What scheme they have given up? That scheme challenge they have given up because their officers came on that day and that.
They have made the 3 prayers.
Now question is 22 plus 1 23 जो ये बताएं.
Submission is that, my lord, kindly see.
उसके ऊपर judgment दीजिए whether who is final. Now here they are
giving my
for
lord right
that
now.
they have a very valid
My lord,
point.
right now I am giving.
नहीं इसमें से कोई एक भी क्वेश्चन ऐसा है जो टेंटेटिव में करेक्ट आंसर लाइक 16.8 ठीक है 16.8 वो सेंसस वाला तो एक एक्सपर्ट ने बनाया था टेंटेटिव आंसर की और एक एक्सपर्ट ने बनाया फाइनल आंसर की सो हु इज द
और ये तो irrevocable fact है.
so who is either it will be the court which will be the
The Census Commission of India has got on the website. It's an incorrigible fact.
Yes.
Irrefutable fact.
My lord, the experts are saying, the tentative answer key means, my lord, the purpose of giving the tentative answer.
Therefore,
So that the
therefore, when they have filed the RTI, why haven't you given the reply that yes, for these questions we have received
My
objections?
lord, we have not given the reply to the RTI. The remedy is not here. Remedy is somewhere else.
So
Remedy is not here, my lord.
he is not seeking remedy. He is saying he is imputing malafide for the
No one
reason
is fighting, my
that
lord.
you are not being
My
transparent.
lord, this petition is not maintainable if they are alleging the malafide kindly see the memo parties, my lord. No officer in personal capacity is the party before the, my lord. How can it be
Your
maintainable?
entire organization will not
My lord, if they are
This is an organization which does not believe in government of India.
My lord,
What
this
kind
is
of
the-
an organization is this?
Okay, so now what are the decisions on which you are relying upon, which will say that the courts can interfere in the expert opinion?
That's to some immediate attention to the other way. In 1405 of Penal,
Have you annexed those decisions?
I'm
there?
sending a copy to the judge. I read up with that.
इनको file करो, अपने
First,
file करो.
give the para
My
number.
lord, let them fight because they are not.
नहीं, you also have your judgments. अब सिर्फ judgments पे बात आ गई है. We have to
What my
conclude
friend
this.
is saying,
हाँ.
only contempt has been stated.
चलो कोई बात नहीं.
I have got it. This is there.
In the judgments that I just handed over, Salil Maheshwari versus High Court of Delhi, in petition 4976 of 2016. The precedents on re-evaluation are only applicable to the context of examinations.
Which para you are reading?
Your para 22 years.
No copy has been supplied from where
Copy
they
has
are.
been supplied.
दे दो भाई कॉपी दे दो.
ये सारी चीजें report हुई हुई है.
Yes, 22. What is the point you want to draw from here?
In multiple choice answer questions, courts and tribunals have the power to intervene. There are multiple judgments on this, starting with Delhi High Court, which follows the Supreme Court, again the Delhi High Court follows it, and subsequently. Okay, Lordship, this is I can hand over further judgments to Lordship, but I don't want to make a bulky record on
Yes.
Shubham
The law is clear.
reiterated each and every judgment of the thing. Here,
ठीक है, the very finding para 22.
Yes, Your Lordship. There would be no infirmity in the approach of a court that directs reassessment, such as in Kanpur University, the Supreme Court, I believe, on the ground that the answer key is incorrect. In the present case, this court has recorded findings on each of the 3 questions to say that the answer key is used for correcting the question paper used one single correct answer. The alternative options cannot be unambiguously clear answers.
Acha, this is one. Now there is one CLAT judgment which
Yes,
has come Supreme Court. Ki. They have, I think, given these similar directions.
Similar direction. Similar. I'm so sorry. I have not the This is really I do it. Really I do it.
See, Supreme Court में हो गया ना CLAT का अभी pending है.
अभी हुआ था, उन्होंने डायरेक्शन दिया था.
इनफैक्ट क्या हुआ था कि दिल्ली हाई कोर्ट ने डायरेक्शन दिया था. सुप्रीम कोर्ट has gone one step further. You said that you will include these 2 questions
Also further more questions.
Want to see the Delhi High Court order, my lord, please. Really,
This is Shivraj Sharma.
Shivraj Sharma and the High Court, it goes to Supreme Court also, my lord.
Yes.
Citizen Deep Lala is the High Court. Supreme Court.
Let's read the High Court question.
कौन सा पैरा है?
My lord, so far High Court is concerned. My lord, from para 2, my lord, just to have a background. First, my lord, the Delhi High Court. The admission notification for common law admission test class 2025 was issued by the respondent consortium inviting applications for admission to undergraduate program leading to award of BA, LLB or BCom. The petitioners submitted their online application seeking admission to the 5-year integrated law programs conducted by NLU. The entrance examination was scheduled on 1/12/2024, wherein the petitioners appeared when assigned was entrance examination scheduled on so and so, and the petitioners appeared and were assigned different sets of out of the 4 set questions paper set A, B, C, and D. The question paper comprised of 120 questions, wherein 1 mark was to be awarded for the every correct answer and 0.25 marks to every correct answer. Now all these things has been separated. It says para 5. Before adverting to the facts of each LPA and petition, it would be possible to consider the loss by report as well as important basis of this court in respect of the fiscal to the red court intervene and examine the correctness of such provisions, the final answer key and extent thereof. In this contest, it will be pertinent to accept and Vijay Singh, Lord May, my friend is relying on this is not the staff selection commission that I then Lord May Salil Maheshwari may friend just now Lord May see Lord May how the High Court has approached it. Para 6, para 7.
So that they have discussed each question and then answered.
2 questions, my lord.
So 3 questions by the High Court and 2 were added by the Supreme Court. Supreme Court has said anything about the power and by the red court to actually direct or go into this behind the expert opinion?
Yes. It has been reaffirmed. 2 more questions have been added. So this is the long and short of
the earlier submission has made specifically for multiple choice questions. One crack is of course the multiple choice questions.
The Supreme Court judgment.
The academician
Even the revised result has been declared by the CLAT. Even the revised result has been declared by the
now that goes without saying in the sense because the High Court has said it is subject to outcome of the OA. Then ultimately will not be subject to outcome of the OA, will not be the entire result to be revised if need be.
Hand over a copy of BPS Chawla where the High Court has dealt with this extensively. If you may just read out one paragraph in issues. BPS Chawla. Paragraph 18, your lordships. In multiple choice questions, the examiner/evaluator, strictly speaking, is left with no role whatsoever. And in fact, most of the examinations with multiple choice questions have not substituted the examiners, evaluators with an OMR. Thus, the rule prohibiting re-evaluation framed with respect to the essay type answers cannot be said to be applicable to the answer to multiple choice questions. That is paragraph 15. Then in paragraph 18, in the present case, we find injustice to have been meted out to the petitioner instead of being declared successful owing to the mistake/error of the respondents themselves. He has been declared unsuccessful. This court in exercise of powers of judicial review is not called upon to undertake any exercise of reappreciation of the answer, but only to correct the obvious mistakes. As my learned senior has pointed out, your lordship, these are very obvious mistakes. The census is a number, the number is that number. The SSC in different examinations has said that number is the correct answer. If your lordship would grant us some time, we'd explain each question as to why their answers are incorrect, your lordships. But the law is clear. There is no question as to the law, especially on multiple choice answer questions. We are therefore of the opinion that the power cannot be denied in such cases. Paragraph 18.
Which were the two questions which were added by the Honorable Supreme Court in the CLAT exam? They're mentioned in the judgment.
It is mentioned in the
Which questions are those?
Last 5 paragraphs.
116, this Gujarat, Goa, Kerala, Jharkhand.
one is Milord made.
Shubham Pal, single bench judgment is there?
Unfortunately, it's a copy. Get a copy in
Milord made.
The 22, 23 questions, according to you, the tentative answer key was correct for all?
Milord.
So they can, so that is one.
ये इनको क्या वो डाउट जैसे हमने पढ़ा भी इतिहास का क्वेश्चन था कि गांधी जी ने अपना सत्याग्रह किस सन में शुरू किया 1918, 1917, 1916। अब हर हिस्ट्री किताब में लिखा हुआ कि 1918 में शुरू हुआ था, अहमदाबाद मिल स्ट्राइक हुई थी। अब उसमें आपको पता नहीं जो एक्सपर्ट्स थे जिन्होंने बनाया था फाइनल आंसर कि उनको डाउट आ गया, उन्होंने कहा ये वेग है तो उसको सबको इक्वल नंबर दे दो। जबकि फैक्ट है कि ये क्वेश्चन है इसमें मैंने देखा है सत्याग्रह मूवमेंट कब शुरू किया था गांधी जी ने, उसमें करेक्ट आंसर है टेंटेटिव आंसर की में 1918। बाद में भी उन्होंने कहा कि कुछ डाउट आ गया हमारे मन में। अब इट्स अ हिस्टोरिकल फैक्ट। अब सेंसस का जैसे आप जाइए इस वेबसाइट पे सेंसस कमिश्नर रजिस्टर जनरल ऑफ इंडिया, वो बताएगा कि हिंदू रेट ऑफ ग्रोथ कितना था। इट्स अ इररिफ्यूटेबल इंडिस्प्यूटेबल फैक्ट। तो ये हम पूछना चाहते हैं, तभी हमने बुलाया भी था, आप पहले भी आ चुके हैं स्टाफ सिलेक्शन कमीशन से। कंट्रोल एग्जामिनेशन है ना आप, डिप्टी सेक्रेटरी। कंट्रोल एग्जामिनेशन कौन है इसमें? जैसे संडे को यूपीएससी का एग्जाम हो रहा है, 15 लाख बच्चे परीक्षा देंगे प्रीलिम्स का, उसमें अगर ऐसे 22-23 क्वेश्चन निकल गए तो क्या होगा?
This issue has been dealt by the Supreme Court, my lord. This issue has been dealt by the
चलिए
Supreme
ठीक है,
Court.
ये आप
Complete my
एक अभी आप ऐसे मत दें, पहले लेट देम कंप्लीट देन वी टेक। हाँ, और कुछ और जजमेंट?
Milord, so far the questions are concerned, Milord, do I have to show you losses each and every question? Four questions
हमने देख लिया था वो आगे। मैथ्स का तो वो जो अलजेब्रिक है वो तो आई थिंक इट हैज टू बी ओनली वन आंसर। वाई और जेड का जो अलजेब्रा क्वेश्चन है।
Even Milord, सत्याग्रह Milord, your losses.
I think I was joking with my sister that I think we should not become controller examinations and become experts.
Unfortunately, Milord, the court has not made do this job.
But I think why should we? In UPSC we never interfere. It's only DSSSB and in the Staff Selection Commission that we are constrained to interfere. We don't want to interfere. Why should we? You do your job meticulously, punctiliously, and flawlessly. Why should we interfere?
It is happening every year.
This is the one side of the argument. And my lord,
Every year.
Wait for your turn, we are only.
Submission is ultimately if this 23 question 22 I have raised in my petition. If ultimately this tentative answer key is accepted as correct but not matched for all this, the entire result will have to be revised. Thereafter, they can apply this normalization principles. No issue. I'm not questioning that. First, they have to change Milord May things. The tentative, they have to accept it and they have to.
But haven't the horses bolted from the stable? I'm told that they have given some. They have given some appointment letters also.
That is the reason. That is the reason. When I went to High Court, High Court said it has to be subject to outcome. And they have published everywhere. So ultimately, what happened in Bengal case was the entire recruited teachers for 20-30,000 crore the Supreme Court scrapped. High Court scrapped it. Bengal government came to Supreme Court just 3 years. So here the situation is the same. If you see the High Court order, when I went to High Court, maybe you also pointed out that there will be certain candidates who are in different jobs. They will resign those jobs, come here, and ultimately, if you lost this revised result, which has to be because of the kind of the answers they have changed. So they will lose even the first job, and they will lose this also. High Court was conscious of all these things. So High Court says this is for final disposal will not be. So High Court said that it is subject to outcome.
इस पे हाई कोर्ट ऑर्डर की भी कॉपी
है।
जॉइंट में लगाई है आपने?
इसमें फाइल में लगी हुई है।
In one other file it could be there.
1405 Muhammad Shami.
OA number 1408 also.
Annexure 810 at page 261 your order.
ठीक है, कोई बात
Still file made for wire.
So writ petition number is
ठीक है, that's okay. चलिए, now there are 22. There is one additional point you wanted to give.
Yes.
Days and total days.
हाँ. Points आपके सारे आगे arguments आ गई. एक argument extra है ना किसी की? हाँ.
Additional issue was regarding computer examination, which was scheduled to be held on 18th of January. And it was rescheduled for 31st. Candidates were sent across India. Candidate who is from Ghaziabad, he was sent to South. South Indian candidate was sent here. Nearly 23,000 students missed that examination.
For the reason, they saw allotment is tentative answer key on 21st. They said, look, we are out. Why should we go and write allotment somewhere in southern part of the country? This is the computer exam. So 20 or 25,000.
23,000 approximately.
They missed this exam. Because they went by this tentative answer key, they did not.
So they were not good even in the tentative.
Even in the tentative.
So
they went by the tentative. And without when they changed that, they look the computer exam, they have to be old later on.
but then that point is not, because now it is only for the final answer. Because if they had were aggrieved of the short time between 15 January to 31st January, they would have come during that period. So that additional point will not have much weightage.
Yes. Hand over a copy of other Supreme Court judgment. On this point of fact, till what point can this power be exercised? If I may invite your attention to paragraph 11 of this judgment, your Lordships. This is again a 2005 Supreme Court judgment.
So this point of computer-based exam has been raised in this student? OA number?
1408.
In 1408.
So these candidates are not aggrieved by that.
And neither.
They are simply pointing.
So 1408 applicants are those who did not sit for the computer-based exam.
They are simply pointed out.
They have simply pointed out that there was too lesser time and therefore 20,000 candidates did not appear. So therefore, those who have finally lucky are facing less competition. This is what you want to drive.
What we are saying is, it will affect the normalization process.
My lord, it will affect the normalization process. This is what we are saying.
Leadership, ultimately, allotment is not a normalization is what allotment. If the total allotment average mark of 18th and average mark of 20th is taken, that is the way allotment is aligned. If these people are out, allotment not.
But then this is
have allotment minor
but this is a regular matter for every selection, because ठीक है इसमें 20,000 नहीं आए हैं, किसी में 10,000 नहीं आएंगे, किसी में 15,000, किसी में 5,000 नहीं आएंगे. So this happens every year. So
notification was given well within the time to the applicant who did should not appear in the exam.
Therefore, अच्छा एक मिनट. Yes. What is this judgment now?
Manish Ujjwali, Lordships, paragraph 11, 2005 Supreme Court decision.
What is the point on this?
Lordships, at any point in time, courts can interfere and direct re-evaluation based on the correct answer. In this, Lordships, we direct re-evaluation of all the questions by feeding correct answers. Our challenge is that the final answer has incorrect answers. We direct re-evaluation of all the questions by feeding correct answers as above noticed. And on that basis, correct number of marks obtained by all students should be assigned and their ranking prepared. So fresh list ought to be prepared.
Which paragraph?
Paragraph 11, you not like.
11.
Yes.
The second movie director.
Observations also make saying why this problematic.
So much power is concerned, is when power is sufficient, you losses have the power. Now, what is to be done? So for these 23 questions are concerned, we have given the examples, the comment report, etc., etc., etc. There is no response from the side. Wait and wait. So you losses have to return a finding that these answers have to be the tentative results should be declared as per the tentative answer. So there are the variations. Because if you losses leave it once again upon the expert, it will go into circles and circles. So
we have to declare the correct answers.
What is the meaning of the tentative answer key? If my lord is final, there is no meaning, my lord, of the final.
Okay.
Lordships require us to go to the individual questions, because there are serious issues and other questions also, which form part of the 23.
So let us hear the respondents on the question of power, because their main contention is in the counter that they have their experts and we are not the field experts and we don't have the power to entertain these kind of questions. हाँ जी, इस पे judgment दिखाओ.
I will kindly come to page 49 of my counter. We start, my lord, and there are one page 46.
Page 49
Page 46, my lord, and there are
of the counter.
yes, my
See
lord.
the judgment.
Counter in my
They
counter
are fine.
file only in one matter.
हाँ,
My
they
lord,
filed.
kindly see page 46.
So first judgment Mahesh Kumar.
Mahesh, or kindly have para 2.
Hmm.
Para 2. Petitioner had filed the royal proceeding. The petitioner applied for combined level examination 2017 under the unreserved and orthopedically affected category as per the result of which that examination dated 15 November 2019. The petitioner was selected for the post of auditor department officer. However, as per the post defense opted by the petitioner had the period of the computer-based model 100 qualifying marks as per the category, he would have become eligible for the post of inspector. The computer-based examination comprised of 3 modules: word processing, speech, sheet, and sensation of slides. Being not satisfied with the result of PPT, the petitioner filed the WPD number 3, which on objection being taken by the respondent is maintainability, therefore the alternative remedy being available was not passed by order to the stated and representation of the petitioner directly to decide with for which the said representation was disposed of 22nd July 2020, stating that the petitioner had secured 97 marks in CPT, having scored 35 marks, model 2 and 62 marks in model 3. The cutoff in the model 2 and 6 was 600 marks for the category. Now, since the petitioner did not secure the cutoff marks, he was declared not qualified in CPT and ineligible for certain category of what the petitioner had requested for revaluation of the answer script of CPT. The petitioner while data dated this. Now, my lord, I may draw the attention at page number 14. This is the active position of the case. Okay, para 4, my
Para 6.
para 4.
We have heard the counsel of the
We
petitioner.
heard the counsel for the petitioner. We heard whether the petitioner wants us to do is to educate whether the evaluation of the answer script of CPT taken by the petitioner as a part of the combined level examination 2017 in order or not, whether the evaluation thereof in order or not, and whether the petitioner CPT is entitled to any marks in excess 97 marks related by the examining authority. Only subject expert and proceed with the evaluation of the answer script not only of the petitioner but of all other similarly placed as petitioner. The same is not in the domain of the court or jurisdiction under Article 226 of Constitution of India. We have no expertise evaluation of the result of an examination list of the CPT. Even in a subject like law, in which judges can claim to have knowledge, Karna Verma versus Registrar General of High Court of Punjab and Haryana reported this, relying on HP Public Service Commission versus Rupesh Thakur and Pramod Kumar Srivastava versus Bihar Public Service Commission. It has been held that court cannot take upon itself the evaluation of the answer given by a participant for the direct evaluation of an independent committee. Moreover, the answer scripts of all examinees are to be examined objectively and preferably by the same examiner, or even if by the different examiner, by the following the same criteria. It is not the case of the petitioner that there is any following the evaluation of the answer script of all candidates who could be the score would not be justified in, even if it is possible for the court to examine, evaluate the answer script to examine, evaluate the answer script of the petitioner only, and which is directly project in disparity and often the floodgates with all others who may also not qualified in the security wanting their answer script also to be evaluated by the court. The counsel for the petitioner has referred. Now come to para 8. Para 8. The challenge in the aforesaid case was in the entire examination as distinct from the challenge in the petition only to the evaluation of the answer script of the petitioner, as after the aforesaid judgment, Supreme Court has repeatedly in Central Board of Secondary Education versus Srivastava, Ran Vijay Singh versus State of Uttar Pradesh, High Court of Tripura versus Tirath Sarthi Mukherjee, Bihar Staff Selection Commission versus Arun Kumar, Vikesh Kumar Gupta versus State of Rajasthan held that in absence of any provision for the evaluation of the answer book in the relevant rules, no candidate in an examination has any right to claim or ask the evaluation of his marks, and the court may permit the evaluation of student only if it is demonstrated very clearly without any intensive process of reasoning or by process of rationalization, and only a rare or exception cases. It was further added that the court should not be evaluated or scrutinize the answer sheets of the candidate as the court has no expertise in the matter, and academic matters are left to the left to academics. It was yet further held that court presume the correctness of simulation and proceed on that assumption that in the event of the doubt,
डिनोमिनेशन लिख के दे रहा हूँ
go to the examination authority rather than to the decision came to be dismissed. Now this challenge before the Honorable Supreme Court, now page 53, my lord. The Supreme Court has upheld the order and judgment passed by the my lord.
यहाँ पे रखेंगे तो यहाँ पे वीडियो को रखा है ना
This page number 54. Maharashtra State Board of
इसका
Technical
पैरा नंबर बता दे बस. We'll go through the पैरा number. You don't need to read.
Para number minus page 57, para 30. Page 2, page 57, para 2.2 and 32. 3.1, 3.2.
57.
Now I am seeking permission of the Honorable Court to draw the attention of one more element.
Run Vijay next. No. Next over here, Run Vijay.
That is the Run Vijay Singh, my lord. It is running. They are also taking the center of this judgment, and I am also, my lord. That is 880, my lord. Annexure R4. I don't kindly come to para 6. Another batch of writ para 6 of page 81. Another batch of writ petitions having 77 writ petitioners came to the district before another learned single judge of High Court. The subject and district were the same, and the learned single judge admitted the activity for final hearing, not to discussing the dismissal of several similar petitions. The challenge made by the writ petition provided 7 questions answers in the written examination, which according to them had correct. He answered. The learned single judge personally examined those given questions and concluded that the correct answer of question number 24 in history paper would be option 1. For question number 25 history paper, option 2 is correct. Option is correct answer for question number 36 of history paper. Option correct answer in respect of question number 37 of history paper. Question number 40 of history paper is wrongly framed. In question number 43, there may be 2 correct answers, option 1 and 3.
अरे माइक बंद कर ले अपना शौकीनदार
Then proceed to observe. It cannot be doubted that the being a selection body of appointment of teachers in the secondary school or as well as the history of region hold selection very carefully, meticulously, and the most honest manner the law of selection board.
अरे माइक बंद कर लो यार अपना अपना
Holding a selection without caring whether examination is being conducted correctly and properly, whether all the questions.
गाइस नेम नोट कर लो इनका जो भी न्यूसेंस क्रिएट कर रहे हैं ना ड्यूरिंग हियरिंग नेम नोट कर लो बस इनका आप लोग मैं कोर्ट मास्टर सर से बात करूंगा आप नेम नोट कर लीजिए इनके बस
It causes a multi-age injury to the otherwise studious intelligent student who understand the subject well or relevant details and correct answers. Coupled with the negligence of the examining body, the obligation of examining body cannot be allowed to white out, written out in the any manner for any reason whatsoever, or the basis of the learned single judge. Thereafter, my lord, this matter came up for my lord. Yes, sir. Para 10. Para 10, my lord. Being agreed by the decision of the single judge, the board build special appeal division bench of the High Court. Some candidates are directed against the judgment.
नीचे माइक का ऑप्शन है उसको बंद कर दो सब लोग
The board was dismissed by the division bench of the High Court. Some other special appeal by the board. 14 September 2010, but now the date of execution as per not affected by the examination. Therefore, a set of petition was
भाई माइक बंद करो सब अपना, हियरिंग सुनने दो।
those agreed by order passed by the bench full file the petition. Now I would kindly come to page 90, my lord, 90. As a result of discussion and taking consideration all of the possibilities that might arise, we issue the following data result prepared by the board consulted upon the decision dated this. High Court should be declared by the board within 2 weeks from today. Candidates appointed and working trained graduate teachers pursuant to the declaration of visit on earlier occasion found unacceptable on third declaration of it should not be moved from service, but should be allowed to continue. Candidates now selected upon trained graduate teachers should be appointed by the state by creating supernumerary posts. However, these newly appointed trained graduate teachers will not be entitled for any consequential benefits. Now, before concluding, you must accessible deed English with the turn of event whereby the learned civil judge entertain the petition. How to be this appeal has highly into several red petition have earlier been dismissed by the learned civil judge. Respect for the view taken by the coordinate bench is essential and element of judicial discipline. Now, I have one important judgment, page number 91. Page number 91.
Para 18 onwards should also be read below.
I've already, you see my file, I've already read it, I've already marked it. Chali Mahesh, this is Mahesh Thakur. Okay.
This is the HP Public Service Commission versus Mukesh Thakur. It is a very important judgment. And
Abhina, you give the paras because there's another important matter एक wait कर रहा है.
Para number 2.
Para number?
Para number 2.
तो बस वो mark करवा दो.
Para number 2, para number 3, para number 4, 5, para number 6, 7. Para number 10.
10, ठीक है.
10, para number 12. Para number 14.
But para 12 we mean because they have framed the issue here.
Para number issue is framed. Para number.
And then the list of judgments are there. Where is the conclusion?
14, 16. All the judgments were discussed. 17, 18. Thereafter, para 22.
Yes.
Now, my lord, this is the operative part. Now, my lord, Delhi High Court in another writ petition. That is the Ashish Singh, page number 103. Kindly come to my lord, page number 109. The petition under Article 226 of the Constitution of India has been filed by the petitioner seeking direction against the respondent to modify the answer to question number this broad question number of India. I test for and examination. The brief fact of the case is that NTA invited online applications for admission for courses for the academic session this. Now, I will finally come to page number 1. Page number, para number 3, page number 11. My lord, the questions as pointed out in the present petition, my lord, has been discussed. Para number 3, page number 1. In so far, question number 69 is concerned the connection of the petition that the correct answer should be given. Both statement, both 5, it is discussed and now relevant para 5, page 112. Learned counsel appearing for the petition while taking forth through the question number 69 submit that the relevant material brought on record along with the written petition would clearly indicate that the answers finalized by the expert are palpably wrong. Accordingly to him, by no stretch imagination and prevent person has little understanding with respect to the subject concerned with complete conclusion or accepting the answers finalized by the expert. He further stated that that's why the material and the expert opinion brought on record by the petitioner to justify their submission the respondents have not placed on record any material to substitute the view taken by the expert. He further states that expert committee now come to the para 8, my lord, page 113. He placed reliance on the decision of the Honorable Supreme Court, Manoj Singh, and the National Board examination. I have heard the council both the parties. It is settled, my lord. It is important. It is settled below that answer key supplied by the paper setters should normally be assumed to be correct, and correctness should be ascertained from the standard prescribed textbook and not merely on the basis of the inferences. Now, para 13. Para 11. What is being contended in the instant case is that the material placed on record by the petitioner indicates that the correct answer were different than those finalized by the expert. Reliance has been placed on the decision of the Honorable Supreme Court on the University. The Honorable Supreme Court UP Public Service Commission versus Rahul has held that when it comes to the conflicting views with regard to the answer key in an exam, then the court must rely on the opinion of the expert and cannot take on the role of expert in the academic matter. With respect to the objection to the answer key, this court in the matter of Kumar Verma versus Union of India, the court have directed to examine body who did not have the procedure of inviting objections. Objections were invited in this case to answer the follow and the said procedure the court felt was necessary to a fair review of the examination. And now I am reading it. Finally, come to last para, page number 15. Under these circumstances, this court is not inclined to interfere in the instant petition. Accordingly, it is dismissed. Now, second petition, my lord, Sivnath petition. Sivnath petition is like in the similar fashion, my lord, same question and everything is raised by the applicant, and we finally come to page 132. Before that, my lord, 130. Para 12, having heard the my lord, have page 130. Having heard the party, this court is obvious that essential outcome the scope of court interference with the result of the examination. The Supreme Court in
Vijay is being followed.
Now, my lord, in another case, High Court of Tripura versus I just relied upon, and thereafter, my lord, this petition is also dismissed. Now, my lord, LPA by the Honorable High Court. In the High Court of Delhi at New Delhi, this is the National Board of Examination. Come to my lord, page 136. My lord has pointed out how can it be wrong, my lord, if census is giving the data on the
website.
So, my lord, this is the answer of the my lord queries at page number 136. The SRS stated that the information is provided by them for all the four choices: birth rate, death rate, maternal mortality rate, and infant mortality rate. On the basis of this, the learned single just pronounced the improvement dated when WC was partly allowed, the foreign direction was given. Now, para 4. The learned senior counsel argued that the incorrect question was not such that it would require judicial intervention, and that learned senior judge approach in awarding 1 mark to candidates in Canadian law as the court must exercise their power within a limited scope of judicial review in academic matters. He stated that the UP Public Service Commission versus Rahul Singh, the Supreme Court has observed that when it came to the conflict with regard to the answer in an exam, then the court must go down to the opinion of the expert and cannot take on the role of the expert in academic matter. The learned senior counsel further stated that the instant case the learned senior had erred by calling for an affidavit on behalf of the Registrar General Census Commissioner when he had no jurisdiction to propose, and that no consent had been sought from the applicant hearing before the said decision was taken. Sri learned senior counsel appearing for the applicant in Rajat for the appellant side, Vijay Singh versus
ठीक है, Vijay again आ गया. ठीक है, next.
Now, my lord, come to para 13.141. The scope, I would have 141. The scope of judicial review may be the scope of judicial review when it comes to the correctness of the answer has been considered time and again by the Honorable Supreme Court, wherein no man has been to entertain such challenge on a very limited ground and give due weight to the opinions of the subject.
ठीक है, the LP has been allowed. चलिए.
Now, my para 14. Para 15 मालूम हम क्या आ गया फिर? Now, para 16. My lord may take note of the same, and my lord appeal is allowed. Para 16. Now, my lord, one more judgment by the Honorable High Court of Delhi in Freya Kothari versus Union of India. The same issue came up for consideration before the my lord, and my lord was given one more judgment, my lord, passed by the Honorable Supreme Court. I am just handing over the copy of the said to you.
Yes, इसके कौन से पैरल हैं?
My lord, kindly come to para 1, page number 2. For the sake of convenience and clarity, we are of the taking fact. This is the my lord case. Balram Vishnu Subramani versus Union of India. For the sake of the convenience and clarity, we are taking fact from the petition number 6. The petition I have paid for determined amount. Calling for the report relating by the answer P for the JE Advance 2017 examination published by the second correspondent in their official website and set aside the same insofar the awarding plus 3 marks to all candidates in chemistry question number 29, code 1, paper 1, and plus 4 marks to all candidates in mathematics question number 39 in code 1, paper 1 and 2. All the corresponding questions in all codes 0 to 9 and further to issue a writ of mandamus commanding the respondent to revoke the 7 marks awarded to the candidates of JEE Advanced 2017 whose question papers were printed correctly and they had not attempted the question and award negative marks in application those attempted wrongly and publish the result of JEE Advanced 2017 and further direct the respondent to publish the revised All India ranking list. It is contended that the petition certain questions were held erroneously, yet it had correct answer and some student has given the appropriate answer. It is urged that the respondent number 2 in an arbitrary manner decided to grant the requisite marks, that is 18 to all of the candidates, because the expert body held that the mistake could be best remedied in the said manner. In the counter affidavit, it is averred that the respondent number 2 discovered printing inconsistency.
But they have expressed their anguish.
Yes, my lord. Now, kindly come to my lord, page number 5 and 4th para. At this juncture, learning additional solicitor. Now, my lord, the issue awarding this once. So now,
you
my
are
lord,
also from
my
the
lord,
respondent side.
I am from the respondent. My lord,
Yes. Give him also a chance. Yes.
Since I appear in OA 1408, my counter is not filed. I will only make submissions which are obvious from the application and from a common man's point of view.
Any new submission which is not been
Yes,
made?
because I will do. Because when the judicial interference in respect to a subject expert's opinion is concerned, a distinction has to be drawn from what is something which is error on the apparent of apparent on the face of the record, or something which is a mistake of fact very clearly, and something a question which is so vague that in an exam where lakhs of students appear, those students, multiple conclusions are arrived at by different students so as to create a confusion in their minds. Therefore, my lords, I will only make submissions from the record only. If my lords have the rejoinder, my lords, for example, the question, according to census of 2011, what was the recorded population growth rate of Hindu religion? My lords, my counter is not on record. I don't know what weight with the subject matters, but my lords, I as a layman applied my logic to my mind to this question, and I thought what objection I can raise to this question. Because the very first objection I will raise in comparison to what? Growth rate in comparison to what? Because this, it says according to census of 2011, what was the recorded population growth rate of Hindu population? Now, my lord, that growth rate has to be in comparison of some year. Therefore, my lord, it's the beginning year and the ending year between which the growth rate has to be compared. Both years are not mentioned. Therefore, my lord, some student may perceive it to be annual growth, some may perceive it to a 10-year growth, some may perceive it to be a 30-year growth.
So basically, what
it's
you
a big question.
should say now, you should employ the experts to frame the questions also.
May I answer that?
Exactly. That may
We have shown from the record.
Yeah, we took your point that the question
Exactly
itself is right.
same question was asked.
In an earlier paper.
Yes.
In JEE.
Now, same question was asked.
So he cannot act.
It's census is not every year.
So there is a system of last 10 years
Last census.
papers and all that.
It is implied last census.
That's a question. In a
Very good.
that point of appearing. My lord, one more. Because in 14 page 14 of the OA, just noted, they have quoted a question relating to an algebraic equation. My lads have put a query that it is a very obvious that how can there be multiple answers to that? Because they themselves stated in OA what has happened in this question paper is given in multiple languages. In Hindi, there was a mistyping, 141 was typed as 114. And therefore, those students who had opted for Hindi and had read the Hindi question would not be able to arrive at the correct answer. Were not able to arrive at the correct answer. It's them.
Yeah, that
What is it?
It's not about
What is it?
everybody.
Question is there. I am
If
saying.
Acha, okay.
If the problem, your lordship, even assuming my learned friend is correct, if it is a problem that is only for Hindi speaking, with the question paper,
Hindi opting.
yes, your lordship, but it has been awarded to everybody indiscriminately, your lordship. I can sleep in the paper and the paper is in English, I will get a mark for that.
Para 14.7 of this advertisement says, let's CHSL 2022. Whether it says if there is any discrepancy between the language, English language shall be.
Apart from
Anybody attempting the English.
In an exam with negative
Not in the
marking,
exam.
in an exam with negative
Even in
marking.
the statute, Lord. It is published from the both in Hindi and English. And it is written there, in case of any discrepancy, English will prevail instead of Hindi.
My lord,
That is what the regulations.
my lord, this is not case of applicant, my lord, any violation of the scheme of the examination, my lord. My lord, once the scheme of the examination is not
No, we are not challenging
My
this.
lord,
No, they are not
My lord, second aspect-
Chaliye, okay,
My
thank
lord,
you.
second aspect of this case is that, my lord, second, one most important aspect of this case is that, my lord. Once they participated in tier 1, my lord, and they were successful, my lord. So can they raise the queries on the second part, my lord?
These questions are of tier 2, na? These questions are up from tier 1.
We will compare it with the shower, but it's my house, not my
So they will see this, they want to be heard.
The successful candidate has done their examination. They have given.
But that High Court order covers the
Because in an exam with negative, what answer is also a conscious choice which a candidate takes and therefore the benefit to all. Lord, you know,
चलिए ठीक है ओके अब वो जो खड़े हुए
My lord, outline, my lord, has provided
Good opportunity to all of us. If you office want, otherwise not it is nothing right.
Yes, and there is a written submission that was no side.
both sides.
okay written submissions within 1 week 10 days within a week
Within a week.
week na? चलिए orders are item 131
तो आए ना बाहर से आए हैं आप लोग आए ना बाहर से
इनकी फाइल निकाली
क्या बाहर से आए
मैंने हमने तो बुलाया नहीं कौन लोग हैं आप लोग I'm calling respondent number 4 MCD